You're into courtroom. I just go ahead and tell them what we're doing, folks.
Yes, Your Honor. The defendant would be entering pleas to 2 counts of CSE first under a different theory, which is criminal sexual conduct during the commission of a felony. The PAC code is 750.520B1C. And if I can kind of explain that, I can then go back over the whole plea agreement. But so what occurred here is the defendant lived in the Chicago area in Illinois. He was 20 years old. He began a relationship communication online with a 12-year-old girl who lived here in Wexford County. They communicated over a number of weeks. It's charged here from April 30th through May 15th of 2023, communicated over gaming platforms and other messaging apps, where during that whole period of time, the defendant sent sexual videos of himself and images masturbating to the 12-year-old victim and induced the 12-year-old victim to create videos and images of themselves naked and masturbating, and had that 12-year-old victim send them back to the defendant. He then arranged, using the same computer, to engage in acts of sexual penetration with the victim, which forms the basis of the current charge of accosting a minor for immoral purposes, which is current count 6, which reads that the defendant did accost, entice, or solicit a child less than 16, the child here being 12, with the intent to induce or force that child to commit an immoral act, to submit to an act of sexual intercourse or gross indecency or other act of depravity or delinquency. So the defendant then encouraged the victim to engage in sexual acts with him, and then traveled the 4 hours from Illinois to Wexford County, and then in a car in Wexford County engaged in multiple different kinds of sexual penetration with this 12-year-old here. So those acts of those immoral acts he induced her to commit while they were here, and he would be admitting to acts of penile vaginal penetration and penile oral penetration. He's pleading guilty also to the child sexually abusive activity of using that, and also using a computer to commit a crime. So the underlying felonies are sort of this ongoing felony of inducing the victim. So not only did he do the inducement of the victim to engage in sexual penetration when he was communicating with her from Illinois, but when he got here to Wexford County, the victim confirmed they were only 12 years old, and the defendant then induced and convinced the victim to engage in acts of sexual penetration. So that accosting a minor for immoral purposes occurred here in Wexford County, sort of right immediately before the defendant then began these acts of penetration that all went on a single day, the acts of penetration here over a number of hours.
All right, thank you. You've got a notepad out there.
Yes, Judge.
What you got, Mr. Dell?
Oh, this is
anything to add is what I'm asking.
What's that?
I'm asking, do you have anything to add to what Ms. House said?
No, Your Honor. I'm looking at my notes, and I concur. That was a proper explanation.
Right.
We don't have any. We consent to that that recitation. And if I may confirm with my client before
sure.
you, or do you want to do it during? You can do it at the plea.
No, you go ahead and talk to your client. I'm going to look something up. Thank you.
For the record, Mr. Mora, did you hear everything that the prosecutor stated?
Yes, sir.
And do you understand everything that she stated?
Yes, sir.
Okay, and have you and I had enough time to discuss the matter and the plea today?
Yes.
Okay, and are you satisfied with my services and how we've come to the resolution today?
Yes, sir.
Okay, do you have any questions about any of it? Okay, do you oppose or disagree with how this resolution has been put together after hearing what AAG House has stated on the record? Okay, was that a no?
No.
Just want to make sure, just so I'm, okay, all right, sir. Thank you, Your Honor.
Take one moment.
Your Honor, I have a second thing, but I don't want to interrupt you, and I just did.
We'll just hold on. All right. My question is, I recalled also, I thought there was a double jeopardy issue.
I didn't hear you, sir.
I said my concern was I vaguely recall there being a double jeopardy issue. In other words, if he can be convicted of the offense, and so that was my concern. So go ahead.
A more
Lisa.
simple solution.
Yeah,
It was so simple, and this is why I missed it. If you look at the felony information,
yeah, hold on.
he's charged, The answer was so simple, that's why I didn't have it before.
That's always right in front of
Yeah,
us. Go ahead.
so if you see, he's charged being 17 years of age or older, and then it says contrary to 750.520B1A is simply a victim under 13. That's the only elements that need to be there. Then it says, and 750B2B, when you add B2B, that's the one that adds the element that the defendant is over 17, and that adds the mandatory minimum. But a prosecutor can charge it simply under the theory of B1A, simply that the victim is under 13. And then as the court takes the factual basis here, the court will take the factual basis of the victim's age and all of the required elements. And there is no required element of establishing the defendant's age when it's simply charged B1A. You don't have to charge another variable with that.
I understand. So then what is the punishment?
The punishment is up to life in prison. So I would amend this to add an amended counts 9 and 10 that are simply charged under 750.520B1A, period. It's essentially an enhancement that a prosecutor can choose to add to have a mandatory 25-year minimum, or a prosecutor can choose to either never charge it in the first place or to remove it now at the time of a plea.
I know, I understand that point. I don't read it that way. So, moment. All right, I understand your argument. I disagree. If he is over, if she is under 13 and he's beyond a certain number of years, I'm going, in regards to how you want to argue it, I'll strike it this way by telling you, I will not treat it that way. So you can't squeeze an apple into the hole. Ain't gonna happen. So I will not accept that as that 2B is somehow an element. It is not an element. It says if A and B, which is, by the way, within the discretion of the court, and therefore if I find if he is over that age, that the answer is no. I won't do it.
You're saying, Your Honor, that what we're doing here is parsing.
No, hold on. That argument. So now we're switching back to your original question. So wait, hold on. The question when you came back here the second time, which is 1C? Yes. 520B parenthetical 1 parenthetical C, which is the commission of a felony. Bingo. So let's work with that thought. as I was saying, I was concerned with there being a potential issue of double jeopardy because does he have to be, not does he have to be, can he be convicted of the underlying felony and the first degree while in the commission of the felony? And let me explain why. And I'm still looking here and I have found a couple of cases that are bringing up that point. That's why I'm trying to ask. So,
You would not be pleading though.
and that's what I was going to ask you. So I couldn't remember what it was, what the felony was that he was committing at the time of the offense. So
He would be committing the accosting a minor for immoral purposes, but he's
He
not
wouldn't be
entering
pleading
a
to that.
plea to that.
yeah, was it
He would
count?
be entering a plea to CSC first, 2 counts, child sexually abusive activity, and using a computer to commit the crime of CSC first. Or if the court would prefer, he could also be using the computer to commit the child sexually abusive activity. At the same penalty.
All right. I'm going to go over the agreement with you, Mr. Dallow and Ms. House, as well as Mr. Mora, to make sure I've got it all. All right, so I'm going to start over on a clean sheet of paper. The defendant would be pleading to an added count or 2 added counts. And those are, one moment, don't anybody interrupt me while my brain is working slow. Added count 9 and an added count 10. Each would be for a CSC first under 520B parenthetical 1 parenthetical C, which is commission of another felony. And that other felony would be accosting.
Yes, Your Honor.
Right. And for that, there would be an agreement that he would receive a sentence of 6 to 20. No, wait, oh, sorry. I looked at the wrong spot. One moment. 12 to 25.
Yes, Your Honor.
There we go. And of course, SORA, and because of the age, there's lifetime electronic monitoring.
Yes.
And we agree, at least the parties do, which is not binding on the court, but helps the court go through its guidelines with him, is that he would score around 108 to 180 months, which is 9 to 15.
Yes.
Okay, then he would be pleading to seconds. Getting rid of count 1, count 2, count 3, count 4, and then count 5. Is that sexual abusive activity?
Yes.
All right, there you go. That is a potential of,
20 years.
yep. And we said that one was the sentence range of 6 to 20.
Yes, sir.
And the predicted guideline range for that, what was it? Tell me what it was. It was 108 to 180, I think. Is that right? No, not 180, because that's 15 years.
It is, it's also an A grid, I believe that is 108 to 180.
Okay, so, oh, that is the minimum guideline range. Okay, copy that. Thank you very much. And then dismissing count 6, but count 6 is the felony for which he was in the middle of committing.
Right, Your Honor, to correct that, the guideline range for child sexually abusive activity is a B grid, it's 57 to 95 months, which is 4 3/4 years to 8 years. So again, our agreement of 6 to 20 years is in the middle of that range.
Okay, thank you. And that activity, how is that different from the activity alleged for count 6? Just want to make sure that is that the photographs and the videos or whatever?
Yes, the child sexually abusive activity is that he did persuade, induce, entice, coerce, or cause a 12-year-old to engage in child sexually abusive activity, which is fully naked pictures and videos while she's masturbating.
All right, thank you. And then what about 7 and 8?
The defendant would be pleading guilty to count 7, which is using computer to commit a crime of criminal sexual conduct first degree, which is that he used the computer to set up this activity occurring. And then count 8 would be dismissed.
All right.
And the other part of the agreement is that these sentences would all be served concurrently. If the court wants, the guidelines for using a computer to commit CSC first are also, it's a B grid, it's 57 to 95 months, which is 4 3/4 to 8 years, maximum penalty of 20 years. And the plea agreement is that he would serve 6 to 20 on that as well, concurrent.
All right, thank you. And let's make sure we got it. Covers all the counts that are listed. It covers the sentence agreement. I don't think there's anything else from this house. Am I correct?
There's not. I do just want to inform the court that I have talked with the victim's family about the original plea and sentence offer, and they were okay with that. I have now talked to them today here about these amendments. They understand that in our agreement.
All right, Mr. Dallow, where's the defense stand on what we just covered?
Defense concurs, understands, and doesn't have anything further.
All right, thank you.
Yes, sir.
All right, Mr. Mora, time for you and I to talk. I don't remember if I did this. I'm just going to do it again. Please raise your right hand. Do you swear or affirm the information testimony you're about to provide will still be the truth, the whole truth, nothing but the truth?
Yes, sir.
Thank you. Now, Mr. Mora, you're a little soft-spoken today, and I'm going to need to make sure you speak up. Now, also, when someone is soft-spoken, you can put your hand down. We're done for that portion. Concerned with their maturity and their understanding as well. Now, I'm going to turn to Mr. Dallow. Mr. Dallow, you've met and spoken with your counsel obviously several times, correct?
I've spoken with my client. Yes, Your Honor.
Do you have anything that you think I need to be made aware of as far as competency, his ability to understand, participate, and so forth?
No.
Very good. All right, so I'm going to trust that because he knows you better than I do, Mr. Dallow. So,
Mr. Mora.
I'm sorry, Mr. Mora. Thank you.
I was going to make a joke right there, Your Honor, but I'm going to leave it alone.
Thank you very much. All right, Mr. Mora. Everything you're going to tell me today has to be the truth, okay?
Make sure you speak up.
Make sure you speak up.
All right.
All right.
We're not trying to give you a hard
Yeah,
time.
no.
We just got to preserve the record. You understand, Mr. Mora, right?
Yes, sir.
Okay.
Mr. Mora, what I'm really concerned here with is making sure that you understand what's going on. As part of your due process rights, I need to ensure that you understand what's going on because it's really serious, okay?
Yes, sir.
All right, good. So if you take anything from what I'm saying, that's what I want you to take. This guy up here is just trying to make sure that we do it right by you and everyone else. All right, thank you. All right, and also, by the way, sometimes people come in here, raise their hand, promise to tell the truth, and then when they get back here for sentencing, well, I didn't really do it. I just pled that way because I felt pressured and blah, blah, blah. And then we end up coming right back and whatever. So that's why I really highlighted some terms. All right, so Mr. Mora, you are currently charged on a piece of paper that's called a felony information. Some people call it a complaint, some might call it a charge sheet. We call it an information, but regardless of what we call it, I'm going to tell you what it says. You know, counts 1, 2, 3, and 4 are all counts of criminal sexual conduct in the first degree upon a person under the age of 13, where a defendant is 17 years or older. Now that is a felony, punishable by a mandatory minimum of 25 years with up to life or any other term of years above that. Additionally, there would be a lifetime electronic monitoring, like an ankle bracelet, things like that, as well as mandatory testing for sexually transmitted diseases and AIDS, as well as lifetime sex offender registration. Now, all of those involve, what I'm being told, a particular individual. Now, those 4 counts are going to be dismissed if you enter a plea of guilty to 2 other counts. And those are going to be counts 9 and 10. Now, there's still counts of criminal sexual conduct in the first degree, but they're under a different paragraph. That's really important. Instead of the plea being based upon the age of the victim, it's now going to be based upon the concept that you were committing a felony at the time you engaged in the sexual penetration with the person. Now, in particular, in this file, it's going to be that you were accosting her for immoral purposes. In other words, you had enticed her to be in a location, you enticed her to engage in these acts, and you used basically your age and your influence to get her to perform these sexual acts of penetration. Now, it's still a felony. It still carries with it potential life punishment. However, it doesn't carry that mandatory minimum of 25 years. That's really important because the attorneys have also told me that there's going to be an agreement that at sentencing, they agree that the sentence will be set at, for those 2 counts, 12 years to 25 years. Okay. Now that's called a killover agreement. We're going to talk about that again in just a couple minutes. So the charges are first 4 counts are mandatory minimums 25 to life because they're both sexual assaults in the first degree upon a person under the age of 13. Well, those are being dismissed if you enter a plea of guilty to, and I accept that plea, 2 other counts of criminal sexual conduct in the first degree, but not based upon the age of the victim, but based upon you committing another felony. Okay? Now, after that, there's another charge on here called child sexually abusive activity. Now, this is activity that allegedly you committed by using a computer to entice her, induce her, coerce her to engage in some sexually abusive activity, such as taking videos of herself, sexual videos, and then sending them to you. That's a felony punished by up to 20 years and or up to $100,000. I'm told today that there's another agreement that relates to that offense, and that is also a sentence agreement that the sentence would be 6 to 20 years. Okay. Now, there's still sex offender registration. I should have told you also for the added counts 9 and 10, there still would be sex offender registration for your life, and there would still be lifetime electronic monitoring. Do you have any questions so far, Mr. Moore?
Oh, but.
Go ahead, Mr. Gallo.
Yes, Your Honor. My client had a question of what electronic monitoring meant, and I just explained it to him.
Do you have any questions of me, Mr. Mora? About lifetime electronic monitoring? It basically just means like an ankle bracelet or device. The technology, by the way, might change, but today that's what it is. And it's basically just that a parole officer will always know where you're at. Okay?
Do you understand that, Mr. Morrow?
Yes, sir.
And have you understood everything so far that the judge has stated?
Yes, sir.
Okay, are you sure? I want you to know, and the judge wants you to know, that if at any point you're not understanding or you feel pressured, you can stop us and we can take a break and we can go over anything that you want to go over. Do you understand that, Mr. Morrow?
Yes, sir.
Okay, do you feel pressured to take this plea right now, or are you prepared to proceed? Okay,
Thank you, Mr. Gallo. Thank you, Mr. Mora. Mr. Mora, there's a count 6 that's going to be dismissed. And that count 6 is the actual charge of accosting a minor for immoral purposes. And that's where you are alleged to have enticed or solicited a person under the age of 16 to engage in some immoral act or act of sexual intercourse. Now, that itself would have been a felony punishable by up to 4 years and or $4,000 plus registration as a tier 2 sex offender underneath the Sex Offender Registration Act. However, that count will be dismissed. Count 7 is a charge of using a computer, which would include a tablet, an iPhone, like a smartphone that connects to the internet, but using some computer to commit a crime for which the maximum punishment is 20 years or more, which would basically be the criminal sexual conduct in the first degree. That means that you used a computer to entice or meet her, make the arrangements. Now, again, that's a felony punishable by up to 20 years and or $20,000 plus reimbursement for any government response or any other expenses incurred by the government in conducting the investigation. In that, the attorneys have also agreed that the sentence would be 6 to 20 years. And you're going to be pleading guilty to that offense. Do you understand? The last one is count 8. Count 8 is using a computer to commit a crime for which the maximum punishment is 4 years or more, but less than 10 years. That's a felony punishable by up to 7 years and or up to $5,000 plus reimbursement to government expenses. That's going to be dismissed. Do you understand?
that count 8 is going to be dismissed. Do you understand that?
Oh, yes.
Okay.
Yeah, and I'm just I speak this way just to make sure the mic is,
Yeah.
so I'm a little OCD about it, that's why.
So, Mr. Moore, there's some other stuff about this agreement that I want to go over with you. They all deal with sentencing. Now, until the sentence comes to the court, I don't really get involved in the discretion. I might make a ruling, like you heard me say earlier, on how I interpret the law, but I don't say anything about, I think it's a good deal, a bad deal. I don't. But when it comes time to sentencing, I alone determine the sentence. Now, we've talked today about some agreements that you have made with the prosecutor's office through the assistance of your counsel regarding sentencing. Now, those are what we call a Killebrew agreement. That word Killebrew, it's just the name that we put on. It's kind of like how we put on the word Miranda to talk about Miranda rights. The word Miranda comes from a U.S. Supreme Court case. Well, a Killebrew agreement means this. It means that you and the prosecutor have reached an agreement. And in this case, I've gone over what those agreements are. The agreements are that for the CSC first degrees, the big ones, the sentence will be a minimum of 12 years to a maximum of 25 years. And for the other two charges, the minimum would be 6 years up to a maximum of 20 years. I don't know if I'm going to go along with that agreement. And if at the time of sentencing that I do not go along with it, then you have the right to withdraw your pleas and come back to this stage of the proceedings, okay? So all the work that Mr. Dallow has done with Ms. House and all the work that she's done with Mr. Dallow to make this agreement, if for some reason I decide not to go along with it, you have the right to withdraw your plea and we won't proceed with the sentence and we'll come back here. Okay? Does that make sense at all, sir? Does it? I hope so. All right. So now there's a reason why I don't commit to a sentence, especially in this instance. I don't know anything about you. For all I know, you are wanted around the world for espionage. I don't think so, but I don't know.
Judge, may I say something?
Sure.
I'm sorry.
It's okay. Hold on.
Ask.
Yep. Mr. Moore, I can see the expressions in your face, and I know you're concerned about how I'm gonna react now, or how I feel. Right now, again, I know nothing about you, so to me, you are as vanilla ice cream. All right, so don't worry. Right now, every tone that I'm taking, every word I'm saying is all about you, making sure that you know what you're doing, okay? All right, and again, if anytime you've got any concern, all you gotta do is turn to Mr. Dowell. I see that he's there paying attention, so. All right, now, if you enter this plea of guilty, you're not gonna have a trial. You understand that?
You understand that you're not gonna have a trial?
Yes, sir.
All right, now, if you enter a plea of guilty, you're gonna be waiving certain rights. Now, Mr. Dallow gave me a form here that says the top of advice of rights, and I'm holding it up. And it shows, looks like your signature on the bottom. Is that your signature?
Yes, sir.
And did you read this document before signing?
I read it with my lawyer here.
Okay, and did you understand it?
Yes, sir.
Okay, now I'm gonna ask you a question and I mean no offense by it. Is English your first language? Or do you also speak Spanish or? I just want to make sure, did you read it yourself
I did, sir.
and you understood the words?
Yes, sir.
All right, the only reason I asked you that is because you said you read it with your attorney and I wanted to make sure that you read it and you understood the words. But for an ounce of precaution, I'm just gonna go over it. If you plead guilty and I accept that plea, you're gonna be waiving the right to have a trial by jury, a trial without a jury if you chose and the court and prosecutor consented. The right to be presumed innocent until proven guilty, the right to have the prosecutor prove beyond a reasonable doubt that you are guilty, the right to have the witnesses against you appear at trial, the right to question and cross-examine those witnesses against you, the right to have the court order any witnesses you may have for your defense to appear at the trial, the right to remain silent during the trial, the right to not have that silence used against you, and the right to testify at the trial if you chose to testify. Do you understand those rights? Okay, and you understand that if you plead guilty and I accept that plea, you will be waiving those rights. Okay. Furthermore, any appeal as to the conviction and sentence pursuant to this pretrial agreement would be by filing what's called an application for leave to appeal and not a claim of appeal by right. A claim of appeal by right means the appellate court has to listen to your appeal. And that's only when someone's convicted at a trial. You could still appeal, but it's by a different process called an application for leave, which means you would be asking them for permission. And it takes different criteria to be able to make that plea. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you were convicted at a trial. Also, you'll be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me today on the record, or that the plea was not of your own free choice. Mr. Moore, are you entering the plea of your own free choice? Are you making the choice? Okay, I'm going to go over that. You pause a little bit, and that's absolutely okay. How old are you, by the way? 22. All right. Well, let's talk about this. The law in Michigan, or the Constitution, I'm sorry, here in Michigan and the United States says that you have certain rights. The attorney, your defense attorney, is there to help you. And when it goes to a trial, he has to decide what arguments to make to the jury, questions to ask lawyers or witnesses, questions not to ask, what evidence to present, not present, all those things. That's what his job is. Imagine him as a military soldier, and you're the general. You tell him, go to battle, and he decides how many bullets to shoot, not shoot, which way to go. But you have to make a couple big decisions all by yourself. He's there to help you. And so I just want to make sure, because this is one of those big decisions. Are you making a decision to plea on your own today, sir? And again, I don't think Mr. Dow is forcing you. I know that I'm quite confident he's doing a good job for you, and he's ready to march forward if you tell him to march. Okay, now have there been any other promises, threats to force you to plead guilty that we haven't talked about today?
No, sir.
Now we talked about this sentence. I'm going to tell you, you also heard these things talked about called the sentencing guidelines. It's a relatively thin booklet, and it's given to us here, and I'm holding it up by the legislature. And it tells the courts, hey, here are these guidelines. These guidelines will give you judges an idea of what we think is a good sentence. But they're just guidelines. They are not mandatory. But it's all up to the court. Do you understand? All right, good. Now, again, doesn't mean that I'm not going to go along with the plea, you know, especially if I'm being told that the victim is in support of it, and which I have absolutely no doubt that Ms. House is telling me the truth. Then there's a really good chance. Okay. So, do you still wish to enter the pleas that we talked about?
Yes, sir.
All right, good. I'm sorry, I said good. Yes,
One
ma'am?
thing, I think that Mr. Moore is a US citizen, but I don't know that he is, and so I do think we need to advise him just in case.
Thank you. Mr. Moore, that's a good question. Are you a U.S. citizen?
I am, sir.
All right, good enough. And I'm glad to hear that. But also in today's world, especially, you never know what that means. Deportation, things like that. Now, I forgot one thing, even though I think I've covered it. There's an agreement that every sentence that's assigned for each one of those charges is going to run concurrently. There are two choices. They can run consecutively, which means, let's say, for example, if I gave you 5 years for every offense, you'd have to serve 5 years, then serve another 5 years, then serve another 5 years. But there's an agreement that it's going to run concurrently, which means they run all at the same time. If I give you 4 sentences and the 2 bigger ones are 12 to 25 and the 2 smaller ones are 6 to 20, you're going to run them at the same time, and the most you're going to have to serve is the 12 to 25. That makes sense?
Yes,
Because
sir.
by the time you reach 12, you've already served the other ones. All right, good. I think you got it. So as to count 5, sexually abusive activity, how do you plead? As to count 7, using a computer to commit a crime for which the maximum punishment is imprisonment of 20 years or more, how do you plead?
Guilty.
As to counts 8 and 10, both criminal sexual conduct in the first degree while in the commission of another felony, how do you?
If I may, Your Honor, sorry to interrupt you. You
Okay.
said, the court said 8 and 10?
I'm sorry, 9 and 10. Sorry, I glanced down and saw the number 9. As to counts 9 and 10 for commission of criminal sexual conduct in the first degree while in the commission of another felony, how do you plead? Before the court can accept those pleas, Mr. Moore, you're going to have to now tell me what happened. Now, I'm going to turn your attention to a date range. It looks like it's about 2 weeks. It's between April 30th and May 15th of 2023. You told me you're 22 now. How old were you at the time of these events?
Yes, sir.
20? Okay. And you were living where at the time?
Illinois.
And where in Illinois?
Plains.
Des Plaines? Okay. And did you have contact with a person over here in Michigan? A young girl?
Yes, sir.
I don't need to know her whole name. Can you just tell me what her first name was?
I believe it's Matt.
I'm sorry, what was that?
Matt.
The victim's
Or
given name at birth was Haley, but victim chooses to go by the name Matt. Yes,
Matt.
yes, Matt.
Okay, thank you. All right. And how did you communicate with this person?
Online.
And so through like what, instant messenger, Snapchat?
No, well,
Sorry, just tell me.
okay. Was it that one?
Yeah.
On communicate on the phone,
How did you talk to that person?
Snapchat.
Okay. And over that, and hold on, Madam Clerk, because of the sensitivity, could we please, oh wait, hold on. The victim is watching.
Thanks for watching. Make sure to hit that like and subscribe button for more crazy court hearings like this one.